My name is Patrick O'Connor. I'm an attorney with the O'Connor Law Firm, and today what I'd like to do is discuss with you a new federal law that became effective on January 1st, 2024. That new law is called the Corporate Transparency Act. The Corporate Transparency Act requires certain corporations, LLCs, and partnerships called reporting companies to file an information form with FinCEN. FinCEN is the Financial Crimes Enforcement Network, which is a division of the U.S. Treasury. The U.S. Treasury also has other agencies known as the IRS. The form is called the Beneficial Ownership Information Request Form, more commonly known as the BOI. And this form is to be filed electronically with FinCEN. Now, who's required to basically file this form? There are exemptions, which I'm going to go over with you in a second. But basically, if you are a corporation, a limited partnership, an LLC, or any other entity that files articles of organization with a state governmental agency, like here in Florida, it's the Secretary of State, you may be required to file this form. Certain entities created after January 1st, 2024 and before January 1st, 2025 must file the BOI within 90 days of its creation. All right, so if you set up a company beginning in 2024, you may be required to file this form unless you fit one of the exemptions. Certain entities created before January 1st, 2024 must file this BOI form before January 1st, 2025. So if your company or business was formed prior to January 1st of 2024, then you've got all of 2025 to get this filing done. Certain entities created after January 1st, 2025 will be required to file the BOI within 30 days of creation. So beginning in 2025, the government has shortened the time that you have in order to file this form. What entities are exempt? Well, banks, venture capitalists, tax-exempt entities like charities, and certain other financial business entities are exempt. In addition, if you have what's called a large company, and the large company is basically an entity that has over 20 employees and has gross revenues as reported on their corporate tax return that exceed $5 million in that year, then they too are exempt. However, if you should ever go below 20 employees or below the $5 million in any given year, you might have to file that form. Here's a listing of the various entities that are exempt. There's roughly 23 of them, but most of them are financial type institutions and investment companies, except for the ones at the very bottom, which are like the large operating companies, which I've just discussed, which is 20 or more employees and $5 million or more in gross revenues. So what information needs to be reported on the BOI? Well, you've got to first report the entity itself. So you need to include the legal name of the entity. If there's any fictitious names like a DBA, you've got to include that information. You've also got to include the address and tax ID number of the entity. The real kicker here is the additional information that you have to include. And in essence, what you have to do is you have to include the names, the current residential address, Social Security numbers, date of birth, along with uploading a copy of either a passport or driver's license with respect to any shareholder who owns at least 25% or more, any officer of the entity, any director of the company, a manager or, quote, persons in control, which we're going to talk about in a second. If a trust happens to own the stock in that company or the membership certificates, then you also have to include possibly the trustee of the trust, the person that set the trust up called settlor or grantor of the trust, and the beneficiaries of the trust. The term persons in control is really broadly defined. And on my next screen here, if you see, this sort of details the persons in control and other types of people that the government wants you to also include on this form. So if you have stock or voting rights in the company, you have to include those people. If a person has any type of capital or profit interest in the company, you have to include those people on the BOI form. If, for example, the company has a promissory note that allows the person that has that promissory note, the lender, so to speak, if that person has the right to convert that debt into stock, you've got to include those persons also on this BOI form. If anybody has an option to obtain stock, you might have to also include those persons on the form. And then there's the catch-all. Any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership, you also have to include those people. In addition, you might have to include somebody that has control over these things, but maybe isn't a shareholder. For example, if you've got a parent that sold the business to their children, and the parent still goes into work and makes the decisions and tells the kids what to do, that person might also have to be included as a person on the BOI form and give the information, which includes the current residential address, driver's license, passport, those kind of things. So here's the deal. You are required to update the BOI within 30 days if there is any change in the information previously reported. For example, let's say that you listed a shareholder on there and you listed that person's current residential address at the time. But say 6 months later or a year later, they moved to a different place. They've sold their house, moved to an apartment, whatever. Or if the company adopts a new DBA, or if they're new officers or managers, or if someone dies, you have to update that BOI form within 30 days of any of those changes. So if anything changes on that form, you must file a new form. The penalties for not filing or even updating the BOI form starts at $500 a day, up to a $10,000 maximum, plus possible imprisonment. These are serious penalties. And in essence, the government is able to go after those, quote, senior officers with respect to this. So you don't have a corporate shield with regards to these penalties or these fines. Now, let me sort of talk a little bit about the self-help people that go out there and set up their own entities. The times they are a-changing. Persons who file LLCs on their own, incorporations on their own, partnerships on their own, look, you're doing it at your own risk. Chances are people that are doing that, they're probably doing it right now. They have no idea that this law is out there. It is something that you don't want to do. Even though, the form might look deceptively simple, if you don't understand the nuances with regards to what's required to be reported and how it's to be reported, you're taking unnecessary risks. In conclusion, this is a serious new law that affects many small businesses. Failure to comply can be very expensive and could result in criminal penalties. If you need assistance in setting up a new entity, or if you need assistance in filing this BOI form, we at O'Connor Law Firm will be glad to help you. We're up to date on this law, and we're willing and ready and able to assist you to make sure that you comply with it properly. Again, thank you for your time. And if you have any questions, please feel free to call us. Our phone number is 727-539-6800. That's 727-539-6800. Or you can email us. My personal email is pat@yourpersonalattorney.com. That's Pat, P-A-T, at your, Y-O-U-R, personal, P-E-R-S-O-N-A-L, attorney, A-T-T-O-R-N-E-Y.com. We look forward to hearing from you. If you need assistance in this matter, we're here to help. Thank you very much for your time and have a nice day.